The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Morning, everyone. Our first case is Southland National Insurance Corporation et al. Versus Lindberg et al. And we will hear from the appellant.
Mr. Chief Justice, Associate Justices, may it please the court, Matt Lindberg for the appealing defendants. I'd like to reserve 5 minutes for rebuttal, please. Going back at least a century, this court has consistently held that reasonable reliance requires something more than just sitting on your hands and hoping that a counterparty's representations are completely accurate. And this court has said so repeatedly in the last decade alone, from Bumpers to Dallaire to Arneson. This court has left no room for doubt that everyone, individual home buyers to the most sophisticated business parties, have that same obligation to perform due diligence. But here, the Court of Appeals ignored those precedents and invented a new exemption to this court's rules. Due diligence is only required in sales contracts, held the panel. But there's no authority to support that rule. The panel didn't cite any, and we haven't been able to find any. So the panel's opinion must be reversed. That's the starting point. But then, where does that leave the law on reasonable reliance? Well, because of this court's recent string of precedents, it leaves the law exactly where it already is. Reasonable reliance requires due diligence, period. It's a simple, bright line rule that the lower courts can apply and that this court has endorsed. It's telling that the plaintiffs in their briefs don't really try to defend the Court of Appeals' new exemption. Instead, their main argument appears to be that an intentional misrepresentation could relieve a plaintiff of their obligation to perform due diligence. But that can't be right because every fraud claim requires a showing of intent. That's already baked into a fraud claim. If the plaintiffs are right that an intentional misrepresentation relieves them of their obligations, then due diligence would only be required in cases of negligence, negligent misrepresentation. And this court would have to overrule Bumpers and other fraud in Chapter 75 cases where the reasonable reliance rule was announced. The plaintiffs also point to a couple of older cases from 50 years ago or so, Johnson versus Owens and Olivetti. And I want to spend a minute just addressing those cases. Let's start with Johnson versus Owens. Johnson versus Owens is a case about active concealment. This is the case, recall, where a home buyer was induced not to do any due diligence because the seller had moved furniture to hide the black soot marks on the carpet and had tweaked the settings on the thermostat to conceal the fact that the furnace didn't work. Those are steps of active concealment on top of the fraud. So to the extent that there is a different rule or an exception in that context, it would require not just an intentional misrepresentation, but some act to cover up or conceal the truth. There is no evidence in this case of such concealment. I think the analogous situation here might be if the defendants had sent over loan documents that were forged, that had, the places where there were change of control provisions, that those had been replaced with different text. That would be active concealment, right? And then the fact that the plaintiffs didn't do due diligence, that might not matter in that case because they wouldn't have discovered anything. They would have found forged documents. So to the extent there is an exception there, it's narrow and would relate to active concealment. Same with Olivetti. Olivetti begins by describing the law as when the parties deal at arm's length and the purchaser has full opportunity to make inquiry, but neglects to do so, and here's the key, and the seller resorted to no artifice, which was reasonably calculated to induce the purchaser to forego investigation, then it says action and deceit will not lie. That is a fraud claim. But the more recent cases show that that is not, that is the correct statement of the law, and that the factual dispute that Olivetti turned on is not something that changes the basic statement of the law that reasonable reliance does require due diligence.
That seems right to me. And, you can think about if we interpret the Court of Appeals holding to say that if it's not a sale, you don't need to do due diligence. I agree with you. That makes no sense. I mean, you can imagine lots of billion-dollar structured financing deals where no ownership is actually changing, but you would expect those sophisticated parties to have a lot of due diligence to make sure the deal would work. But what if, when we see that focus on the idea of a sale, what the court was really getting at was that when you're, for example, a lot of these cases involve buying or selling a home, you basically have all the time in the world. So you can say, well, before I actually buy the home, I've got time to go out and do due diligence. And what if what was going on in this case is the trial court was saying there is a time constraint in doing the MOU that doesn't exist when you're selling a home. The insurers couldn't just say, well, let's take our time, really dig into this because we're in no hurry. The house will still be here a month from now, 6 months from now, and so on. So could that have been what they were really getting at there? Was just that's the very specific sort of fact-intensive difference here that means the lack of due diligence is reasonable?
I don't read the Court of Appeals opinion that way. I don't know that it's possible to read that kind of depth into their citationless analysis, but I'll accept it on its face. Is that a possible rule, that there could be a haste-based exception? I don't think so, Your Honor, right? Because this is a case not about what level of reasonable reliance is reasonable, or, is a little bit of due diligence okay? Is a lot of due diligence okay? Those kinds of fact-weighing issues are exactly what go to a fact finder to decide. This is really that bright line case, like so many that have come up before this court in the last decade, which is, what about when there's zero? And so in a case where there's time pressures or other exigencies, zero is still not enough, right? And really here, all that the plaintiffs needed to do, I'll give an example. Brian Stewart, who was a CFO, who was charged, works for the plaintiffs, he was charged with preparing the schedules to the MOU, including the list of loans that are at stake. He testified that he was provided with reams of paper. This is, it's in the trial transcript at 309. And he said that he had access to all of the loan documents. He said, though, that his review was just, he didn't worry about the underlying documents of the investments. We were just looking at the summary table of data. So all he did was take the data that a summary page from what he was given and attach it to the back of the MOU. He had access to the documents. He just didn't read them. And in that sense, this boils down to a duty to read type case. And to be clear, and to your point, Your Honor, it's not a duty to read everything. We have never taken the position, nor have I seen it in this court's case law, that due diligence means perfect diligence. It just means more than zero. It means more than no diligence. One of the things that the plaintiffs, I think, are trying to do in their new brief here is something new, which is to argue that they actually did do some diligence. But that ship has certainly sailed by this point. I mean, the Court of Appeals held that they did no due diligence, and they didn't file a PDR. They didn't seek additional issues on that. Their briefs in the Court of Appeals said they did no due diligence. They actually were asked this question pointedly at the Court of Appeals argument. Did you do any diligence? And they couldn't deny that they didn't do any. So that factual setup is correct. The way the petition as granted here, that is in fact the true facts. I guess that's the way to put it.
So is the rule, if no due diligence, no reasonable reliance, or is it something a little more subtle? In Bumpers, and I think you quote this in your brief, this court said reliance is not reasonable where the plaintiff could have discovered the truth of the matter through reasonable diligence, but failed to investigate. Seems to me that's not exactly the same thing as saying if no due diligence, then no reliance. That seems to say that if no due diligence, no reasonable reliance, if you could have discovered the truth of the matter through due diligence. Am I missing something, or?
No, Justice Allen, that's exactly right. And I think that's what I was trying to say, perhaps inartfully, with this kind of active concealment idea, which is, or maybe it's kind of a harmless error type idea, right? Which is that had the plaintiff tried to do due diligence, would they have found anything? That's kind of the forged documents hypothetical that I gave. In this case, though, the evidence shows that it's more of a duty to read type case, right? I mean, Brian Stewart had those loan documents before him. Peter Nordberg, the in-house counsel for the defendants, sent over a sample loan document, and the plaintiffs admitted that the loan documents are all essentially the same. All they had to do was read those. So to the extent that there is this kind of harmlessness exception that Your Honor is correctly identifying, here the facts line up to show that the plaintiffs should have done at least some due diligence, and they would have discovered that there were problems here.
And Counselor, is that true? Even though my understanding is there were many, many contracts involved. There were many of these documents that should have been read. Are you telling us that that's really a question of fact as to where that line is?
Well, no one requires perfect diligence, right? And the plaintiffs do say a couple times in their brief that our position is that we're requiring parties to read everything. That's never the standard, right? I mean, that may be good business practice, but that's not the standard for the law. The standard for the law is to do something. It's the failure to investigate at all that Justice Allen referred to. So
and so for me to understand, where that line is that a question of fact? Is that your position?
It's a question of fact if the number isn't zero. If the number is zero, it's a question of law. If there's some level of diligence, then yes, a fact finder should be able to decide whether it's reasonable. But there's a real benefit to having that bright line rule at zero. And that is that by all means, we want to discourage fraud, of course. But we also don't want to encourage parties to sit on their hands. Parties should be out there protecting their own rights and taking some steps to investigate. And it's in their best interest, of course, for a business reason anyway. We're not dodging the breach of contract. As this court knows, we asked for a limited remand to implement the specific performance on the breach of contract that was awarded. This really is just focused on this narrow additional remedy of whether fraud lies as well.
Well, and I'd like you to comment on my concern. The reason I asked the question is when it gets to reasonable reliance, is it the law that you rely on the person who is telling the truth, or do you rely on, or do we give favor to the one who's not telling the truth, the fraudster? And that's why I'm asking this question of fact issue, because I certainly, and I understand the precedent, but I certainly do not want to set up a situation where we're enabling fraudsters and requiring too much for due diligence for businesses.
Absolutely. And this court's precedents, I think, already set the line where it should be, which is that some diligence is required. The question of where that line is after some to medium to a lot is something that a fact finder can determine and that individual juries or judges can come up with. And this court has laid out exactly these competing policies before. They're cited in the Johnson case, and it's actually just a quote from an older case, which I believe is called Callaway. And I think it's a good recitation of what the court is going for there. Let me look.
Well, and Counselor, I think what I'm struggling with is what is best practices versus what is the law. And so what I'm hearing you say is no due diligence would say there's not justifiable reliance. Anything above that would be a fact-finding situation?
Well, I want to be clear because Your Honor is getting at something that I don't think I'm speaking clearly about. If there are factual disputes, they have to go to the fact finder. If there are no factual disputes, then as this court said in Lake in footnote 8 and in many other cases, that is a legal question, right? So the underlying facts can be found by a fact finder, but there's a reason that a lot of these cases are decided at summary judgment. And that is that sometimes there's no dispute on the facts. In fact, here there's really no dispute on the facts as to how much diligence was done as to the representation. So it is a legal question. And a court at summary judgment or JNOV, or in this case after a bench trial, could look at some level of due diligence that's more than zero and decide that it's unreasonable as a matter of law. Absolutely. So for purposes of whether something needs to go to a jury, a case where there's no due diligence at all doesn't need to go to a jury.
To go back to the harmlessness exception to the no diligence rule, why isn't that, in this case, something for a fact finder?
Well, the concern here is that it's clear on the facts here. There are no facts to find, right? I mean, harmlessness or lack of investigation is something that can be gleaned from this record without any additional facts. This is, because this case isn't summary judgment, it already went to trial. We already had witnesses testify. The plaintiff's witnesses have already locked themselves in that they didn't do due diligence. And their position, which is understandable on a practical level, was we just decided to rely on what they told us. And you know, that's fine for breaches of contract. That's fine for breaches of warranty. That's why parties include representations, so that you can have a warranty, you can have a claim. But fraud is a different beast, right? Fraud is something in addition to being able to sue on breach of contract or warranty. And this court says that that requires something more. It requires that reasonable reliance and that due diligence. Here, the record, I think, is clear based on the trial transcript that there was no due diligence. There's no facts left for a fact finder to find.
But isn't it possible? I mean, for example, we know that the insurers had access to some of the contracts that I guess had some sort of acceleration clause that is what they say led here to the breach. Isn't there a fact question about whether someone, in reviewing what I assume is probably a pretty complicated loan contract, would have seen, this is an acceleration clause that will mean that the MOU can't actually be undertaken? I mean, I'm just wondering, is that a fact question, or is it your view that just what's in a contract is just a question of law somehow, that we don't ask what you just assume you would have known everything that's in there?
I think that there could be close cases where it's not clear exactly what an investigation would reveal. This isn't that case. This is a $1 billion transaction. These are loan documents. Loan documents have change of control provisions. In fact, the plaintiffs testified that when they discovered that later, they weren't surprised. They weren't surprised to see that. And that's because that's what loan documents say. So, I'm not a transactional lawyer, so I don't have much expertise in this, but sophisticated parties know to look for these things. Change of control provisions they're going to be in loan agreements, these kinds of triggers of defaults. And indeed, that's why Mr. Dinius put this representation in the contract. He knew it was an issue, right? The fact that he proposed it is all the evidence you need that he knew that this is the kind of term that would be in these documents. He knew that was an issue. So he knew it was an issue. He put a representation in as a warranty, which is great. We want contracting parties to do that for breach of warranty purposes. But to then do no investigation on the clause that he inserted into the contract when he knew it was a material issue, that is per se unreasonable. There are no facts to find. He would have found it, having already flagged the issue, he would have found it had he looked, and had the plaintiffs looked at any of the loan documents. There's another kind of flavor of this argument that I see in the plaintiff's briefs, and it is this idea that when a party understands their own structure better, if they have kind of an asymmetry of information, that's a carve-out, that's an exemption from this court's rules. It is not. For sure, that's the kind of factor a jury might want to weigh, but it is not the kind of thing that changes this court's basic bright line rule. Every transaction involves a party who knows their own business better. I can't imagine a transaction where that wouldn't be true. So this would be the kind of exception you could drive a truck through that would eliminate the benefit of the bright line rule that this court has. The Court of Appeals analysis of this muddied the waters. The citation-less statement that this rule only applies in sales contracts is unhelpful and confusing. This court has this unbroken line of cases saying that these are legal issues that can be decided at summary judgment and that no due diligence is per se unreasonable. And now we have the Court of Appeals opinion out there carving out some exception that's not clear. Other courts are watching, lower courts are watching. There are other cases where these issues are at stake. So this case does present a clean opportunity for this court to say that more than zero due diligence is required. That is the rule. I want to be responsive to the court's questions, but I can also reserve my remaining time for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellee.
Good morning, and may it please the court. Caitlin Poe here for the plaintiff insurance companies in this matter. In the spring of 2019, the plaintiff insurance companies and the defendants, including Mr. Lindberg and his other non-insurance companies, were on the edge of a financial disaster, and time was running out. Taking advantage of the plaintiff's efforts to help the defendants fix the problems that they had made, the defendants lied to plaintiffs to induce them to provide over $100 million of loan relief and additional loans. Their fraudulent misstatements were contained in the representations and warranties in the MOU agreement. In those representations and warranties, the defendants said, among other things, that their pre-existing agreements with other parties didn't prevent them from performing their obligations under the MOU. They later revealed that was not true. To prevail on their fraud claim, the plaintiffs must have shown at trial that their reliance on the defendants' misrepresentations were reasonable. And reasonableness is an issue of fact that is determined under all of the circumstances unless the facts only support one conclusion. Here, the trial court sitting as fact finder found that under all of the circumstances, the plaintiff's reliance was reasonable. And the Court of Appeals unanimously found that competent evidence supported the trial court's finding. That holding fits squarely within this court's prior precedent, including Bumpers and its other opinions, and the opinions from the Court of Appeals applying those decisions. We respectfully request that this court affirm the Court of Appeals findings for three main reasons under the totality of the circumstances. First, the plaintiffs could not have discovered the defendant's misrepresentations through a reasonable amount of additional investigation. Two, the plaintiffs had no reason to suspect that the defendants were lying to them. And three, obtaining the representations and warranties was a reasonable protective measure for the plaintiffs to take under the circumstances. So first, as to the ability of plaintiffs to discover the defendant's misrepresentations through a reasonable amount of additional investigation, the defendants point to a sentence in the Court of Appeals opinion that plaintiffs conceded that they conducted no due diligence on this transaction. That was not found as a matter of fact by the trial court, and it's not true. The plaintiffs did due diligence on this matter, and we didn't concede otherwise in the lower court, nor could we have. In pages 17 and 18 of our briefing, we discussed the diligence that plaintiffs underwent, and it was extensive. The trial court heard testimony about it from plaintiff's CFO, Brian Stewart, as well as the defendant's CFO, Krista Miller. And that included exchanging voluminous information, which Mr. Stewart testified that he did review. They had valuations prepared to make sure that this plan to try to fix the investments could potentially work. They had work done by a firm called Alvarez and Marcel, which is an enormous restructuring firm. And they worked to prepare complete and accurate schedules in the attachments to the MOU. Now, the defendants didn't request and review all of the defendants' agreements with other third parties. The defendants in their briefing say that the plaintiffs had those agreements or had a legal right to get those agreements, but that's not what the trial court found as a fact. The trial court found that there are two groups of companies. There's the insurance companies, the plaintiffs in this matter, and then the defendants are Mr. Lindberg's other non-insurance companies. The trial court found, as a matter of fact, those two groups of companies were managed separately, and that plaintiffs didn't, as a matter of course, have access to the defendant's documents.
So do you agree with your friend's assertion that it was your clients who put the provision into the MOU that discusses the breach of potential acceleration clauses with restructuring and things like that?
That was not found as a fact by the trial court. The record is ambiguous about that. Where we first see that in the trial exhibits is in a version of the brief that was sent by Mr. Dinius to the defendants. Mr. Dinius was supervising the plaintiffs on behalf of the Department of Insurance, but at that time he wasn't running the plaintiffs. So when Mr. Dinius was asked at trial who drafted these, he said he couldn't recall. But at the end of the day, it doesn't really matter who drafted the representations and warranties. The defendants signed the agreement. They adopted those statements, whether they had drafted them or someone else had drafted them and said, are these right? When they said yes, they became their own admissions.
I guess the reason I asked is because if this was important enough that you put it in the MOU, and it's a question where the answer can be found by looking at the actual contracts between these lenders, for example, and the defendants here, then it seems like the sort of thing we've described in some of our case law as what we would consider due diligence. You would at least have to say, I know it's somewhat standard to have clauses like this in these loan contracts. Can I see an example of one of the contracts so I can confirm that's not in there? That's somewhat unusual.
What the case law requires is that the plaintiffs, the victims of the fraud, have taken reasonable measures to protect themselves. And here what they did was that they asked for these representations and warranties to be made by the defendants. And they asked that of another party to the contract, Edwards Mill Asset Management, and they didn't agree to those statements. The defendants did, and the trial court did find as a fact that they were knowingly misleading plaintiffs when they did that. Now, whether it would have been easy to ask for those documents and review them, that's not been determined by a fact finder. What the fact finder did find was that those other agreements between the defendants and other third parties were voluminous. There were hundreds of companies, and there were all different types of agreements at issue. And the amended judgment and order talks about some of those different types of agreements. They weren't all the same. There were notes back to sellers. There were loans from third parties. There were equity earnout agreements between some of the selling parties. To look at one of those, which is the defendant's proposed new rule, their new bright line rule, that all plaintiffs had to do to get to a jury was to ask for one of those. How is that in service of the policies requiring investigation, which are that the plaintiffs must have done something to protect themselves? We don't want people sleeping on their rights. And we don't want people to say that they're being fooled when in fact they were not fooled. Those are the policies that are underlying the requirement of reasonable diligence. And how does reviewing one contract of hundreds, potentially thousands, versus asking for the representations and warranties here under all of the other circumstances of this case, which I want to discuss also, how is that in service of this policy when that bright line rule has never been articulated by this or any other court?
Well, and I do want to get to those other issues. I have questions about sort of the time constraints, but I guess my response to that would be, we're not concerned so much about just the facts of this case, but this is a published Court of Appeals opinion, and I'll give you some examples. I mean, in the future, I think if we just would affirm this opinion, there's going to be insurance companies that come into court, and some judge is going to say, well, you're sophisticated parties, and the policyholders you're dealing with are not, and they're going to say, no, Your Honor, we're not sophisticated business entities. I mean, that was a holding of the Court of Appeals in this case, that your clients, insurance companies, are not sophisticated business entities. And similarly, I think it's fair, as your friend pointed out, to say that the holding of this Court of Appeals decision is there's no due diligence requirement if you're not selling something, and which doesn't make a lot of sense. So that's what I'm trying to sort of wrap my head around, is that you are sophisticated business entities, your clients, in my view, and sophisticated business entities would say, oh, you're telling me that you have contracts that don't have clauses that are somewhat common in the industry. I'll just believe you, instead of saying, can I see one of these loan contracts? Because there's usually a provision in there, and then you'd think it would be in there. You see what I'm saying?
Absolutely. And I don't think that the plaintiffs would take the position that the insurance companies, obviously they were sophisticated insurance industry professionals. But what the evidence that was in front of the trial court also was that none of them had experience in M&A, none of them had experience in private equity. The defendants managed all of their investments. And so I do think that takes this out of the situation where an insurance company could say, in general, I am an unsophisticated party, because I do think it's cabined to the facts here, where it was a bit of an unusual situation where nobody else at the insurance company had experience in these types of transactions. The defendants handled that for them. And the defendants, by contrast, they bought and sold companies. That was what they did. They had a team of dozens of personnel whose only job was to buy and sell companies on behalf of Mr. Lindberg, who compared himself to Warren Buffett before this court and at trial. And when they were looking at what are the effects of these clauses, the defendants should have known how those worked. And from the plaintiff's perspective, they believed that they could rely on the representations of how they worked because that's what they did. They bought and sold these companies. Just because a change of control provision exists doesn't mean that every transaction is going to trigger it. It's a complicated legal analysis. And that's actually illustrated in this case by what happened after the breach occurred. And that's that the defendants took a number of their valuable operating companies and they placed them into what's called change of control trusts. And Mr. Lindberg talked about this at the trial. The equity of those companies was moved into trust. And it didn't cause the parade of horribles that the defendants said would happen if the plaintiffs performed the MOU. So it just goes to show that it's not always an obvious question of would this contract necessarily trigger this change of control provision? And from the plaintiff's perspective, there was reason to believe, even if they knew there might be good chances that a change of control provision existed in some of these contracts, that it wouldn't necessarily be triggered here. Because this wasn't a simple sale to a third party. That's another important fact here. This wasn't a sale to a third party. It was a movement of these companies under independent management temporarily. And that independent management was still a subsidiary of the existing holding company where Mr. Lindberg remained the sole shareholder of that ultimate parent. Mr. Lindberg and his appointees and the independent members of the board formed a controlling majority of these companies. And after plaintiffs' loans were paid back, Mr. Lindberg was going to regain control of these companies. So when the question was put to the defendants, does this trigger these change of control provisions? Can you do this transaction? It wasn't simply in the blind, is it reasonable to accept that answer? Under the specific circumstances here, it was a reasonable conclusion. And that's what the trial court ultimately concluded. And to believe the defendants here isn't just to accept that Mr. Lindberg was a good person. It was in his own self-interest to be making these representations and warranties only if they were true, because it would have hurt him just as much if they were false. Take, for instance, one of his group of companies, the Eye Care Leader group of companies. They provide software services to eye doctors. And in the representations and warranties, they are saying, essentially, performing the MOU won't make this bank that we have a loan from default us and accelerate our loan. Now, from the plaintiff's perspective, as indirect lenders to eye care leaders, they don't want that to happen. They don't want that company to be foreclosed on. That would be bad. They would probably only get paid back pennies on the dollar of their loans. But from the defendant's perspective, getting foreclosed on is a disaster because their equity interest in that company is wiped out entirely. And so when we talk about the plaintiff's reliance on the defendants and their representations, it's in that context where it really would have been self-defeating for the defendants to have been lying about that. And the plaintiffs understood that because they're not babes in the woods, but they're also not private equity professionals. And under all of those facts and circumstances, that's the situation in which the trial court found that this was reasonable under the circumstances. Now,
so can I ask you about you asserted early on that that these businesses were on the brink of collapse, which, as you just pointed out, would be bad for them, but also bad for your clients because they need those investments in order to stay in their insurance business. So what about that? What in the record can show us that there was some sort of urgency there wouldn't be at issue, for example, when you're getting a loan from Bank of America for your home and things like that?
Right, and obviously time is always valuable to any business. But here, there was a situation that was unique in that the trial court found as a fact in paragraph 44 of the amended judgment and order that the plaintiff's ratings agency, AM Best, was imminently planning a downgrade of the plaintiff's rating, which in the insurance industry is a catastrophic event that would have led to, and this is what's anticipated, when the rating gets downgraded, then policyholders start worrying about, can I get my money back when it's time for me to get my money back? And so what they do is they go to the insurance company and they try to get it back right away. It's the run on the bank from It's a Wonderful Life. And so with that coming, what happens obviously is the first policyholders who show up get paid, the later ones might not. And so there has to be a stop put on all of that, which is achieved by putting the company into liquidation or into rehabilitation. Had that happened without any plan to fix the plaintiff's investments, and the MOU was that plan to try to fix the investments, there would have necessarily been a huge shortfall in the funds that were available to pay those innocent policyholders who were relying on those investments to get fixed. And so again, although time is always valuable, this was a situation where there truly was an imminent disaster coming for both the plaintiffs and for the defendants, all of which notably would affect Mr. Lindberg as the common owner of both companies. And so when plaintiffs believed that they were working together to try to solve this problem, again, it seemed to be in Mr. Lindberg's own self-interest, which is relevant to the reasonableness of their reliance on his representations here. Now, the defendants cite to Bumpers for the proposition that diligence is always required, but as Justice Allen pointed out, that's not what Bumpers says. Bumpers says that reliance is not reasonable when the plaintiff could have discovered the truth of the matter through reasonable diligence but failed to investigate. And so what Bumpers is actually asking the court to do is to engage in a counterfactual of what that reasonable investigation would have been and what it would have yielded. And that's been applied throughout the case law in this area. If you had turned on a faucet, you would have seen that the well is dry. That's Callaway. If you had asked your bankruptcy lawyer about your loan, like you did before, he could have told you about the loan priority, and that's Delaire. But then we come to other situations where it's a little more complicated. In state properties, the buyer was purchasing property and the seller had represented there's nothing buried under the soil. Now, what would the additional investigation have been? They would have had to take soil borings to figure out that that's not right. And that's not reasonable. That's not required to get to a jury, to make their reliance not per se unreasonable. That's not required. Similarly, in Cummings, the seller claimed that there was no water intrusions in the property, but it wasn't obvious from the initial inspection that those water problems still existed. It wouldn't have been easy to find. There's not a reasonable amount of additional investigation that would have revealed the problem. And there was a dissent in that case, but the dissent wasn't saying you should have taken down the drywall to find the leaks. It was parting ways with the majority regarding the extent of the duties that the seller's agent owed to the buyers. It's not at issue here. The Bumpers rule is harmonious with how the Court of Appeals applied the Phelps-Dixon holding that fraud claims are not barred when a victim has a lesser opportunity to investigate and the fraudulent representations couldn't be readily or easily verified. That's the flip side of Bumpers. Those are the two sides of the same coin. It's asking about what more would you have to do to figure this out? Would it be easy to figure this out? And the answer here was no. Because these loan agreements were voluminous, because they were all different, because the plaintiffs didn't have the same level of expertise or the same working familiarity with these documents that the defendants did.
What's, and maybe you're in effect answering the question I'm about to ask, but what's wrong with this argument? The fact that you have these provisions in the additional terms and conditions, these warranties regarding third-party agreements, is itself a demonstration that the parties, of the importance, the potential importance of those documents to the parties, and therefore, if you will, for lack of a better term, evidence that you should have examined at least some of them.
The issue was important to the plaintiffs, absolutely. And there's testimony that from the plaintiff's CEO, Lou Hensley, that he wouldn't have signed the agreement without it. But obtaining protection for oneself it's evidence of the fact that the plaintiffs did do something reasonable under the circumstances to guard against that. I think that this would be a much more difficult case if the plaintiffs had just had an oral conversation with the defendants about this. Can you do this deal? Yes, no problem. And then we moved on. Obtaining those written representations and warranties was a step beyond that, and one that demonstrates that the plaintiffs were trying to do something that was reasonable under the circumstances, under their ability to do things, and reasonably protective of their interests under everything else that was in play at the time.
But can you see how someone might look at it and say, you're essentially flagging that this is really important, and then saying, no, we don't need to see it?
The only other alternative, though, would have been for plaintiffs to get all of those contracts and review all of them. Because although the defendants are trying to set out a rule that just getting one would have been enough to make this from per se unreasonable to per se reasonable, we're talking about defendants that the court found intentionally lied to plaintiffs in a way that was warranted punitive damages to punish their wrongful conduct. And so I do think it's a little inconsistent to then say, oh, but you could have trusted me that the one contract I gave you was the one that would have revealed this problem. There's no evidence that this problem existed in every single contract. They were all different. And especially in light of the fact that then defendants were able to move these companies into these change of control trusts without causing all of these defaults and accelerations that they warranted wouldn't happen under the MOU either. Who's to say that reviewing one contract, reviewing 10 contracts, reviewing all of them would easily have revealed those under the circumstances? And remember, this isn't the plaintiff saying this is the best thing that anyone could have done. We per se were reasonable. The question is, does a fact finder get to think about it? Does a jury get to consider whether this is reasonable under the circumstances? And here, the trial court did. We moved beyond summary judgment. We went to trial, and he concluded that it was reasonable under the circumstances. And Judge Wood, Judge Flood, and Judge Zachary, they looked at this, and they agreed that evidence supported that decision. Notably, the representations and warranties that we're talking about today dealt with the effect of the third-party agreements on the ability to perform the MOU, but those weren't the only representations and warranties in the document. There were other representations and warranties, including, for instance, that all of the companies were identified on the exhibits to the MOU to either be moved under this independent management or not, and that was a product of negotiation. Now, that would have been an advantage to Mr. Lindberg, to have there be a valuable company that he just didn't tell the plaintiffs about, that he got to keep to himself, that wasn't moved under this independent management to pay back the plaintiffs. That's a situation where Mr. Lindberg and the other defendants, their interests diverged from the plaintiffs. And so with respect to the completeness of those exhibits, what did plaintiffs do? They checked them. And there's testimony about Mr. Stewart, plaintiff's CFO, when he's talking about preparing correct and complete addendums and exhibits to the MOU. That's what they're talking about. They're making sure that they found all of those things. And so when there was a limited amount of time because of this imminent downgrade from AM Best, limited resources, what did the plaintiffs do? They focused their efforts on the things that it seemed like they should check. Did we get all of the companies? Have we had an analysis done to make sure that if we give the defendants all of these benefits, that we actually can get these loans repaid and the policyholders made whole? That's the diligence that they did do. They had a limited number of resources, a limited amount of time, and they dedicated it to the things that made sense to do under the circumstances. And the trial court heard about all of that, and he understood and concluded that what they had done here was sufficient to support a finding for reasonable reliance. Now, the MOU contract, like all contracts, allocated risk among the parties. And a review of all of the documents that we're talking about, those agreements between the defendants and third parties, maybe plaintiffs could have done that if they had more time, if they had more money, if they had the expertise or had the ability to hire someone outside. But even doing that doesn't have the same value to plaintiffs as the representations and warranties themselves do. Because that representation and warranty is allocating the risk to the defendants of being wrong about the effect of the MOU on those other contracts. If they're mistaken, it's a breach of contract. But if, as here, the trial court found it was an intentional lie, then they've committed fraud. And to rule for the defendants and to say that that is per se unreasonable, it denies contracting parties the ability to make that allocation of risk between each other. And that's inconsistent with the law in this state, and it shouldn't be changed to form that way. There's no authority saying that there's no authority holding that obtaining representations and warranties is not a form of investigation. And here, under all the circumstances, that was a reasonable protective measure for the plaintiffs to take. The law of the state has always been that reasonableness of reliance is an issue of fact unless the facts support only one conclusion. The court shouldn't accept the defendant's invitation to create a new bright line rule because fraud is not susceptible to bright line rules. Reasonableness is ordinarily not susceptible to bright line rules. The court shouldn't require as a matter of law that parties engage in expensive and time-consuming review of voluminous documents, regardless of the nature and circumstances of the transaction at issue. The Court of Appeals correctly found that competent evidence supported the trial court's finding that plaintiff's reliance was reasonable under the circumstances, and we respectfully request that that key holding, be affirmed. And if the court has no other questions, I cede the remainder of my time. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Your Honor. May it please the court. The issue isn't whether a party does some diligence in general on the transaction. The question is whether there was due diligence done as to the representation on which the fraud claim lies. And so when the plaintiffs point to the idea that they did some economic analyses, that's all well and good and makes business sense, but that's not the legal question. The legal question is, if you're going to sue on a specific representation, have you done any diligence on that representation? And the facts here are clear that they have not. In fact, the plaintiffs have admitted that they had a different strategy, and Ms. Poe reaffirmed it here today. They had a business strategy that with limited time, they were going to investigate other things and just rely on the representation that they're now suing on for fraud. The question before this court isn't whether that was a good business decision or a reasonable allocation of their resources. The question is, when a contracting party chooses to do that, chooses to forego due diligence, what happens next? And what happens is they have a breach of contract claim, they have a breach of warranty claim. That is the saving grace, and that absolutely puts pressure on parties in the marketplace to tell the truth. But they cannot, on top of that breach of contract claim, have a fraud claim if they elected as a strategic matter or by accident to do no due diligence. Ms. Poe said that this involves a complicated legal analysis and that that's what plaintiffs would have had to do. But that is exactly what happened in Del Air. Recall that the question there was the parties disputed whether it would have been easy to find out if this BB&T lien was still on the books because of the Del Air's previous bankruptcy. And this court said, too bad. These are regular folks, and this court said, you should have hired a lawyer.
And the other party's Bank of America. Two people getting a mortgage.
Right.
Should have figured out the priority of the loan.
Right.
Well, even when Bank of America tells them, oh, you'll have first priority.
Exactly. And so that case touches on so many of the themes we've discussed today, including the fact that the counterparty had better knowledge. Well, of course. I mean, the loan officer at Bank of America, that person is an expert and should be able to figure it out. Is it reasonable for those plaintiffs to just trust that person? Maybe it's reasonable as a business decision, but can you pursue a fraud claim? No, because that's not reasonable reliance. And so this case really is on all fours with Del Air. This court would have to reverse Del Air to rule in plaintiff's favor today. And then this question of sophistication. I mean, we require homeowners to do due diligence over $1,000, so surely we require sophisticated parties and insurance companies to do due diligence over $1 billion. Briefly on the facts, Mr. Hensley, who was plaintiff's representative, he was the person who signed the MOU for the plaintiffs. I would point the court to the transcript of the trial at 156 and 160. He said and testified that he knew that there were going to be consents needed from third parties to effectuate the MOU. He knew that there were seller notes and EEAs, these equity equivalence agreements, that would require other parties to come in and sign off. And it's the same with these change of control trusts. I mean, Judge Shirley, the trial court, had to have a hearing to set up those trusts. And the fact that it was able to be done with consents and with process isn't dispositive of anything. I mean, the plan all along was that after the MOU was signed, that there was going to be a lot of work left to do before it closed, which is common in complicated transactions. Shoot, it happens even in homeowner buying a house, where there's the day you sign it and then the day that it closes. But the facts here, the facts are, I'm sure, not this court's principal priority, as Justice Steitz notes, right? The opinion in this case has to stand for any set of facts and provide guidance to the lower courts. And luckily, this court has already mapped out what that rule is. We're not here asking for anything other than what Delaware already says. The legal rule that applies across the board, the bright line rule, says that some diligence is required, more than zero, and the marketplace will take care of how much diligence is appropriate in a given situation. You know, a few minutes for someone who's cutting your lawn, and maybe months and $1 million of diligence for $1 billion deal. Nor is there a need for a remand here. The facts have already been found. There's already been a trial on all the issues. The record is as complete as it's ever going to get. And this court can issue a legal ruling, just reaffirming the principle in Delaware that some diligence is required. These plaintiffs already have specific performance. They have a remedy on this. And a remand just creates a situation where parties are encouraged to pursue contract and fraud claims simultaneously, even if there had been no reliance. So for that reason, we ask that the Court of Appeals opinion be reversed, and that this court reaffirm the basic rule in Delaware and other cases that parties are charged with the responsibility to perform some level of due diligence before they can pursue a fraud claim. Thank you, Your Honor.
Thank you, counsel. Thank you both. Mr. Clerk.